Good morning, we're on the record. Good morning again, we're on the record. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2-571HC of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage Board, the Alcoholic Beverage and Cannabis Board. This meeting has been conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2-577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the district's central meeting calendar. The notice included the time, date, agenda, and the call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson, I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your names. Mr. David Meadows.
Good morning, Mr. David Meadows, present.
Mr. Ryan Jones.
Mr. Ryan Jones, present.
The board has 3 members in attendance of the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 6 cases scheduled for our calendar today. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will they have the ability to enable their equipment. If your case has not been heard, you'll remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case in our calendar this morning, it's a fact-finding hearing. It is the Mirage, license number 129298. This case has been continued to a date to be determined. The next case on our calendar, another fact-finding hearing, Crush Embassy, license number 128107. Good morning, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Good morning. Shaheen Nasir Zadeh, access elevated, and Barry Doyle, access elevated. That is all.
Thank you.
Good morning, present.
Hold on a minute, please. I need everyone to come on camera if you're able to. Hold on, please. All right, so let me have the parties introduce themselves. Let's start with I'm sorry, hold on. All right, let me see, what did I, hold on 1 minute, please. I just did something. Let me figure out how to undo what I just did. All right. All right, so let me have the parties introduce themselves for the record. So, who's the owner?
Good morning. My name is Shaheen Nasirzadeh. I'm the owner and major shareholder of Kush Embassy.
Can you please spell your name for the record? So we have a court reporter, so it can be spelled correctly in the record.
Absolutely. Shaheen, Shahin. Last name is Nasirzadeh. N as in Nancy, ASSIRZA, D as in David, EH.
Pronounce it one more time for me, sir. Your last name?
Nasirzadeh.
Mr. Nasirzadeh. Good
Perfect.
morning, sir.
Thank you.
And who's with you, sir?
I
who's the other
have
person?
Mr. Barry Doyle with me, who's been assisting me throughout the whole process. So he thought he'd join, just in case.
So, Mr. Doyle, can you please spell and state your name for the record?
Yes, my name is Barry Doyle. That's BARRYDOYLE.
All right, so. All right. This is just a fact finding here, sir. It's my understanding that the license was approved. You signed a settlement agreement with the ANC, and the purpose of this hearing is just to get some, just some. I'm sorry. What I keep on doing this? I'm sorry. The purpose of this hearing is just to get some just get more information about who you are, who the management team, to make sure that you are aware of the regulation. So, Mr. Um, Nasir Zadeh, just give me a little background about who you are, sir. Give me a little background, sir, about who you are.
Um, Background, I migrated to the US in 1984 with my whole family, moved to Los Angeles originally, then became a resident of DC. A couple of years ago, myself and a few partners decided to see if we can attain a cannabis license in DC. And we've been working towards that since then. There have been up and downs, but we tried to do everything by the book. And once we signed the settlement agreement with the neighborhood commission, things started moving more progressively. We wanted to make sure that the neighborhood is on board with what we want to do.
So, tell me about what type of experience, if any, do you have in this industry, either here in DC or anywhere else? And now this is not a got you question, sir. So it's just and again, it's a fact finding here. We're just finding out information. No one is sworn in. Nothing you say because you're not under oath. So
Okay.
there's nothing that you can say here that we can use to impeach you because you're not under oath. So that because this hearing it's an informal hearing. So I just want to let you know that this is an informal hearing, and the board cannot, in these type of hearings, the board cannot order you to do anything. We can ask questions to say, oh, would you do this? And you can say yes, no. But the board, because it's an informal, because the fact finding here, we're just gathering facts. So the board cannot legally order you to take any specific action, okay?
Okay.
I'm sorry.
As far as my experience, thank you for the info, by the way. As far as my experience, I have some limited experience in the retail space and cultivation space of the legal market of cannabis. I am familiar with the metric system, and all the regulations that some states have applied, some more strict than others. But as far as my experience, I would say it is limited, but I'm learning every day more and more.
Huh. Now, so again, you give me your management structure. Who are the owners and the management team for Kush Embassy?
I'm the major shareholder owner. I will be in charge of daily operations. We have a few investors who are limited shareholders who are going to be silent partners. We have one gentleman, his name is Clayton. He will be assisting me in running the store. He will be management. And from myself and Clayton, we would be hiring more staff as the business grows.
All right, so this is I'm not sure, and so there is in the sense of having silent investors, depending their ownership stake. There is there's a requirement off the top of my head. I can't say whether or not what's the minimum number of ownership that has to be reported to our agency, but I just wanted to make sure that if parties, I know that in the alcohol sphere, if they own more than 10%, they need to be on the license. I'm not quite sure though for cannabis, but just want to let you know that just to make sure that you're complying with the agency's rules and regulations in the sense of who owns what and whether or not these individuals must be known to even if they're silent partners, depending what percentages they own, they must be known to the agency. Just as an FYI, I'm just letting you
I
know.
appreciate
Okay?
the info and we are aware. Thank you.
All right, thank you. Because as I said before, this is just fact finding. This is to make sure that normally when I see folks, it is not because they have complied with the law. It's because they have not complied with the law.
Okay.
So this is one of the opportunities that you're meeting the board, and it is because the board is just trying to find information. It's to be informative, to make sure that you do not appear before the board again. Okay.
Okay.
All right. So as whatever questions, because it's more informal, whatever questions you have, we can, well, to the limited extent that I can answer, or I can direct it to the appropriate person in the agency to answer your questions, that's fine. And so who's making legal and management decisions for the business?
I am.
Yeah. So just share with me your business model for your business.
Our business philosophy is very simple. We have noticed a lot of the stores that are opening up are geared towards tourism. We decided to go another way and be a part of the neighborhood and become part of the community. So our business model is geared towards community relationships, giving back to the community, and growing with the neighborhood that our brick and mortar store is placed. So our business model is community based, not so much tourist driven.
All right. So what other products do you intend to provide to the community?
All cannabis products that are legally permitted for us to carry, like flour, like gummies, and anything else that may be available in the DC market. We are aware that we can only purchase products from producers in DC. So we would be carrying all those products that are available to us and legally permissible for us to carry in the store.
Well, you have answered one of the questions I was about to ask you, so that's fine. Now, let me ask you a question. You said you do have some limited experience in the industry. Just give us some more information about how did you come about this knowledge?
I consulted for a few companies in California, helping them set up a store and a cultivation operation. So I helped the owners navigate some of the legalities and the operational procedures to help them set up their business. But I was never actually hands-on involved. I had a consultation role.
All right, that's good to hear. Does the business have any Schedule I substances in its possession, either on site or at another location?
No,
Does the business have any non-cannabis products in its possession, either on site or in another location?
no.
And I know that you did state earlier that you were aware that all the products that are sold in your medical facility has to be purchased from either from a DC licensed cultivation center or a manufacturer. Is that correct?
Absolutely.
So how many how many employees do you believe that you would hire to operate this business?
Initially, besides myself and Clayton, we're hoping to bring in 3 more employees, and uh, hopefully we can add to that as the business grows and our clientele base accumulates.
And where are you if say for if the agents was to issue the license tomorrow, how quickly could you open?
Contractors can be unreliable. We still have to build out some cabinets and display cases, but optimistically, within 60 to 90 days, we would be able to have our grand opening.
All right. Okay. Any questions by any board members? Go ahead, Mr. Meadows.
Yes, good morning, Mr. Nazir. Thank you for joining us today. So your property, you're at 7530 Georgia Avenue. That's a pretty large property. Are you leasing that space?
The size is larger than we needed. However, the owners of the building, which we are leasing, yes, did not want to divide the property up for us. We originally wanted less square footage,
Sure.
but we were able to make a deal with the owners where we did acquire the whole building, but we're only using about 2,500 square feet of it to do the dispensary. The remaining building will remain vacant. If our business grows, we may add to the square footage.
Okay, that's good to hear. And you mentioned your silent partner, Clayton. Is that a first name or is that a surname?
Clayton is not the silent partner. Clayton is a small shareholder
Okay.
and will manage the daily operations with me.
Mm-hmm.
And all the silent partners, including myself and Clayton, are in our paperwork as far as the ABCA requires.
All right, but is that his full name is Clayton?
Wiedermeyer.
Okay. And you mentioned earlier that you hope to add, of course, the retail market as it is, you hope to hire at least 3 additional employees.
Yes.
I just, hire who you feel is best, but I hope that you could find someone that's a DC resident up in that Georgia Avenue neighborhood. It would help you connect with the community, definitely.
That is exactly what we're looking to do. Actually, the commissioner of the neighborhood is going to help us find a few people from the neighborhood. I have a very good relationship with her. So yes,
That's
we will
good.
absolutely do that.
It's good to hear. Thank you very much. And nice to meet you virtually. And thank you.
Thank you, Mr.
Thank you, Mr.
Meadows.
Chairman.
Right. Any other questions by any of the board members?
No.
Mr. Nazi, is there anything else you want to share with the board before I end this hearing?
I just want to thank you for your time. I have no questions at this time.
Well, thank you, sir, for your for your appearance this morning. Thank you for providing your information. Oh, let me ask you one quick. Can you please just spell the person who's going to manage the property with you? Just state again and spell his name for the record. And the reason I ask is we have a court reporter, so at least the name will be reflected in the court in the transcript.
Yes. I just want to make sure I spell it correctly. So let me get the paperwork from my phone so I can spell it correctly. I don't want to get the name wrong. There's a lot of emails on my phone. Give me 1 second, please. Here we go. Barry, do you have the paperwork with Clayton's name on it?
Yes, I do. I submitted it.
I think we
Yes.
sent it to Jocelyn yesterday.
Yep. Here we go. Give me a second here. Clayton. You can spell his name. Last
I know
name.
I know how to spell his first name. My concern was his last name. I didn't want to get it wrong.
All right. I'm bringing up the summary share so that way I have it proper. There we go. Okay, what happened there? All right. So Clayton's name is spelled WESTMEIER.
All right, thank you. All right, thank you for that information. The board will take this matter under advisement, and we will advise the agency the next step to take towards the issuance of your license. But as I stated before, we have these hearings. They're informal, and just trying to gather information and to make sure that the board doesn't see you because you're not complying with the law, and in the sense that if for us not to have another hearing where it's more formal. And welcome to the District of Columbia to doing business with ABCA. Our agency is here. We're not a got you agency. This agency, we're here to help you. If you don't understand how to do something, you can reach out to the agency, and we will provide you all the guidance. Our website also has a whole wealth of knowledge and information you can rely upon, but you can always reach out to an individual in the agency if you do not understand and if you do not know, and we will provide you the guidance. We're not gonna, if you reach out to us and if you're doing something wrong, we're gonna provide you guidance and instructions first. We're not gonna like, oh, because you're doing something wrong, so we're gonna issue some type of infraction. We're gonna try to educate you to comply with the law. And one last thing I want to say to you is just to be reminded that you are operating a medical facility, and that only folks who are registered with a medical card can be sold products within your facility. And I need to make sure that only folks who have a medical card can be. I'm going to hold you, the owner, responsible for every infractions that are made in the establishment, in the sense that you need to make sure that yourself and all your employees are properly trained how to provide this medical this medication to patients within the District of Columbia. And so I need you to ensure that you and your employees are properly trained, that you manage the employees properly so that they reflect well on you. I don't want to ever have an opportunity where it's like, well, that was a rogue employee. Well, someone had to, yes, we have rogue employees, but I think when you hire the employee, if you share with the employee your business model, what is it that you expect from them. I don't believe that you'll have a rogue employee. Okay?
Okay. Thank you,
But
Mr. Anderson. Understood.
all right. Thank you very much for being here today, and have a great day. Thank you.
You as well. Thank
Take
you.
care.
All right. All right, the next case on our calendar, it's Ahola license number 129362. Ms. Doriana, can you please elevate the rights of the parties in this case?
Good thing. Cameron Mixon, access elevated, and Aloha, access elevated. That is all, Chairman.
Thank you. Good morning, Mr. Mixon. Can you please identify yourself for the record, please?
Morning, Mr. Chair. Cameron Mixon, counsel for the applicant Aloha, Cameron Mixon.
And is your client here this morning, sir?
Yes, we're joined by the license or the applicant, Salah Salim.
Hello.
Mr. Salim, good morning. Can you please
morning.
please spell and state your name for the record and identify yourself for the record, sir.
Yes, good morning. My name is Saleh Salim. That's Saleh. Last name Salim, Salim.
And you're the owner of this establishment?
Yes, correct.
All right. All right. So, as Mr. Mixon, you're aware, it's a fact-finding hearing, and you're aware that for fact-finding hearings, the parties are not under oath. They're not sworn in. It's more informal. The board cannot order the licensee to take any action. The board might ask questions. The licensee can refuse to do that, and there is really nothing that the board can do. And also because the parties will not be sworn in, and so therefore nothing that you say here can be used against you because you're not under oath. But all right, so this establishment, so we are so this is a whole lot. They have applied for a medical cannabis retail license with delivery endorsement. And so there's been some issues with, not necessarily with, some issues with Mr. Salim. And so I'm just trying to find out what involvement, because there's been, there were some unlicensed establishments that were before this board. The board had issued some summary closure notices, and it appears that Mr. Salim might have had some involvement in some of these other agencies, other establishments. So I'm just trying to find out some clarification about what involvement, if any, did Mr. Salim have in, I guess, Tobacco King, Buds and Roses, like Tobacco King and Buds and Roses. Did he have any involvement in these establishments, and specifically, what was his role in these establishments? I mean, you can either have Mr. Salim respond, or you can respond on his behalf as his representative, Mr. Mixon.
As an initial matter, I've discussed with Mr. Salim his history of business ownership in the District of Columbia. To clarify, there are a variety of Tobacco King establishments within the District of Columbia, some of which either are or have been under Mr. Salim's ownership, and some of which have not. The board may be aware of one that was located on U Street, which was subject to an ABCA enforcement action due to which was acquired by Mr. Salim after it had already been in operation. Subsequent to Mr. Salim's acquisition of that business, there was a prior owner of the Tobacco King business, was running their own unlicensed online delivery operation under the name Buds and Roses.
Mr. Mixon, I know you're being an attorney, okay? The question I'm asking, okay, you either answer the question or let him answer. I don't need you to give us all the preference. I don't need you to provide me what's being provided. It's a yes or no. Was he involved in it? I mean, he's on the cusp of receiving a license under his own name, okay? And I don't know that, so I don't know. I don't know if he's been involved. The name Salah Salim, that it could be a common name, okay? It could be a common name. So the question I'm asking, is he the Salah Salim who was involved in these establishments? And just what role is it that he played in these establishments? Because I want to make sure the purpose of this is to ensure the purpose of this hearing, if we were to move forward and issue this license, is that I don't have the pleasure of seeing Mr. Salim again. I see you almost every week, Mr. Mixon, but that is because that's your job. So I don't have a problem seeing you every week. I enjoy seeing you every week because that's your job. However, I don't want to see Mr. Salim again. So I'm just asking questions about, is he the Salah Salim who was involved in these other establishments, and what was his nature of his role? And Mr. Salim, unless your lawyer tells you to answer, you don't answer for your own protection. Okay, so you have a lawyer.
Okay.
He speaks for you, and unless he tells you, you're paying him highly to speak for you, and he's a good attorney. So unless he tells you to speak, please, sir, don't say nothing. Okay, for
Understood.
your own
Understood.
protection. Okay.
Yes, understood.
Okay.
Thank you.
I can
Listen.
amend my answer to be a little more brief, Mr. Chair.
Thank you, Mr. Mixon. Yes.
It is correct that Mr. Salim has owned and does own businesses called Tobacco King, and we'd be happy to elaborate if the board has specific questions about the history of these businesses.
Well, I guess what I'm trying to find out is that because Tobacco King was an unlicensed establishment, and I'm aware that prior to how some folks have moved into the business, because they were running and they were formerly was it I-71 or what? Yeah, but I mean, so in order to transit for some folks, in order to move into this business legal marketplace, we allow some people who are operating legally. But once the law started, once the law was effectuated, then you were not supposed to continue. But when we had issues with Tobacco King, and when we had issues with Buds and Roses, and we had summary closures, it was like, okay, you know what the law is, and you continue to operate. And I'm just trying to find out was he in management? Was he overseeing these establishments when we issued these summary closures?
Mr. Salim, if you'd like to provide the kind of the story around the Buds and Roses situation in the U Street location.
Yes, Mr. Nixon, I think I can. Just to give a quick explanation, what had happened is I had actually purchased that previous business that was it was called Buds and Roses. It was located at 1203 U Street, I believe. And when I had bought the business, we had transferred. Basically, we had opened a new corporation under TK 1203, and we're in the process of changing the business, basically, and having our own sign while we're working on the sign permit. It was still named Buds and Roses. What had happened is the previous owner that sold me the place was actually operating an online website that we never knew of, that was under budsandroses.com or Buds and Roses Delivery. and he actually had access to the Google page where he was making illegal cannabis sales, under the same name as a business, and basically delivering them to people's residents. Like, people, I think they would call Yelp or something. We had control of the Google page, but then Yelp was still under his access, and it was a different phone number. So people would call like, "Hey, I want to, come in, or I want to buy some, some stuff, I guess, that was still illegal, that was not allowed to be sold." But then he was over there saying, okay, he'll deliver it and play the impression of he still owns a business.
And I think it would be helpful also if you could elaborate on just briefly, what is it that, for what purpose did you buy the business, and what was the actual business model that you were running there?
Yeah, we actually, the business, we bought it as, I wanted to basically turn it into like a tobacco convenience store. The other owner that had the business, he wasn't actually doing good, and he posted it, I think, on Facebook or somewhere, through a friend of mine, that I heard that he was trying to sell the business, because it was basically, it was just a cannabis business, and he didn't, evolve into, selling snacks and convenience store items, and, bongs and stuff like that. That's basically, like accessories to, like just a smoke shop, a stereotypical smoke shop. Yeah, I think, I hope that makes, I hope you get a clear understanding of and then that's how the store ended up getting raided. But things were sorted out, and it was cleared up that I had nothing to do with that website, which was the Buds and Roses Delivery or something like that.com.
So, all right. Well, I don't have the summary closure notice, so I'm not gonna go further anyway. So let me ask you a question. So who is the if this license was to be issued for a whole lot, who is the management? Who is the owner and the management team for this business?
I'm the owner of the business, and this time, for this business, basically, I'm gonna be hands on. I'm gonna actually, we're not once things get moved forward, I'm gonna actually have a management team that's gonna be there, hands on, and I'm also gonna be involved hands on in the operation, and making sure, everything operates smoothly.
No, are you the 100% owner of I guess the business model, what is it? Is this an LLC? I guess it's TK 539 LLC, and the name is a whole lot. So, are you 100% owner of the LLC, or are there other partners?
Yes, I am. I'm 100% owner of the LLC, sir.
Okay.
The LLC.
Now, all right. So, have you have you hi- have you hired a management team as yet, or are you just thinking into hiring a management team?
No, I am gonna have a management team that's gonna be, involved in running the business, and I'm also gonna be involved. They're gonna also, basically manage the day-to-day operations, and making sure everything's fine, while I overlook everything.
And to just expound on that on timeline wise, Mr. Chair, the business is currently working at receiving a new updated certificate of occupancy in order to proceed to approval. And so we're on a timeline of where I understand there is something around a month to 2 months before any such construction and inspections are done in order to be granted the new certificate of occupancy. So decisions like staffing are still being worked out in the interim.
All right. Thank you, Mr. Mixon. And so, do you plan to hire? So you haven't hired any employees as yet for this business, is that correct?
No, I haven't. No, that is correct. Like Mr. Mixon said, we're still basically in the stages of obtaining our certificate of occupancy and business license, and setting up a few showcases.
Now, do you plan to hire anyone who worked at Tobacco King or Buds and Roses, the Buds and Roses dispensary, to operate this in your dispensary if the license is granted?
Yeah, definitely. We're not gonna hire anybody that's involved with Tobacco King or Buds and Roses. It's not like anyone is involved now with them. Those whenever went through those incidents, turnaround is very hard. So we had a lot of, new faces. But even if the new faces that hasn't, they're not gonna be. It's gonna basically be a new team that runs Aloha a lot. Separate, which is a high end, medical cannabis dispensary. That's good. That's it's gonna be community based basically.
Um, but there was a question I was going to ask you. All right. You are aware of Tobacco King, the problems with Tobacco King. You're also aware of the problems with Buds and Roses, with the summary closure. Are there any mitigating precautions set in place to ensure illegal activity that occurred in Tobacco King or Buds and Roses would not occur in this establishment if the license was granted?
I can take this one, Mr. Chair. I have advised Mr. Salim to take advantage of one of the ABCA approved training programs so that any staff brought into.
Hold on a minute, Mr. Salim, are you still there?
Yes, I'm still here.
Okay, go ahead.
I think the cameras went out. I don't know.
Yeah, it did, and that's why I want to make sure you're still there. Go ahead, Mr.
Okay,
Mixon.
I'm here.
So, we're aware of the specific training program, employee training programs that ABCA has officially endorsed, and Mr. Salim will be putting the staff that he hires before his opening through these programs, so they're fully aware of best practices for compliance with DC law.
So how will Mr. Salim ensure that illegal activity will not occur if this license is granted? It will not occur in his establishment.
As I've advised him, he's aware of the responsibility to only source cannabis from holders of validly issued manufacturer or cultivation center licenses. And because of his on-site, hands-on oversight and that of his managers, they'll be regularly monitoring purchase records, the storefront itself, supervising such that there's no errant rogue employee conduct.
Now, so what is Mr. Salim's, does Mr. Salim have any background in cannabis here in the district or some other jurisdiction?
Mr. Salim, you want to tell them about your business history?
And Mr.
Yes,
Salim,
yes.
you're not under oath, so
Okay.
nothing that you say here can be used against you because you're not under oath, sir.
Yes, I actually I've been in the retail basically tobacco convenient store business since I was 17. I started working there when I was in California. Then I made the move. I moved here actually about 12 years ago. I moved to Virginia, and then I opened my one small shop in Waldorf, Maryland. And then after that, I actually expanded in that type of that type of business, which is just tobacco, cigars, high end cigar shops. Expanded from there to over 60 stores. 60 stores, and I opened a few in the District of Columbia. Majority of my business is actually done in the Virginia, which is Virginia. It's a tobacco state basically. But I've been in the retail business, since I was basically 17, which is retail customer service. Currently, I have a coffee shop that I'm actually opening in Virginia. That's a little bit different than just the convenience store side that I'm in, but it's mostly generally just stays in the customer service area, retail basically.
All right. Mr. Salim, are you aware that you can only distribute you can only distribute, store, and sell medical cannabis products provided by DC licensed cultivation centers and manufacturers.
Yes, yes, I am aware. There are a few licensed cultivator centers in DC and manufacturers that we will be making all 100, obviously, 100% of the purchases from them to in order to, to like flowers, edibles, wax, and vape cartridges.
Does the business have any Schedule I substance in its possession, either on site or at another location?
No, no, we don't, sir.
Does the business have any non-medical cannabis products in its possession, either on site or other location?
No, 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 we don't.
Any questions by any other board members? Go ahead, Mr. Meadows.
Good morning, Mr. Salim. How are you today? I do have concerns about these 3 businesses that were closed for illegal activity. I do believe that you, Mr. Salim, have the qualifications to run a business. I think that I do have a concern, though, that perhaps you do have a lot of business entities, and you would not really pay as much attention to this store located on 8th Street Southeast in the Barracks Row. Can you speak about that? Because earlier you did mention that you would be a hands-on manager of the establishment. So how would you be able to split your time between your numerous business entities?
Yes. Good morning. How are you? A lot of the businesses now that I have, I do have multiple businesses across the state of Virginia and in Maryland. But a lot of my business that I have now over the years, with as we grow up and life changes. Now I have 3 kids. I'm married. It's not the same. So over the years, what I actually started doing with a lot of my other businesses is I started actually, selling a percentage of my business to a partner that can actually take care of it. That can actually take care of my other businesses other than obviously the cannabis, shop in DC. That's how I'm gonna actually free up my schedule and have some time to be more involved into the 539 dispensary in DC.
Thank you. And that's understandable. You had a partner, Mr. Gebremesco. Are you still in partnerships with Mr. Gebremesco?
I'm not sure. No, I'm not sure. Mr. Cameron, do you know anything about the question? I'm not sure of that name. I don't know.
I'm not familiar with the name. Is Member Meadows, is he listed in a prior order
Yeah,
related to
he's listed
action?
in a case report with the Tobacco King and Vape on 14th.
I mean, if he's not, I mean, if he's not familiar with the person, then if you have a specific name, Mr. Meadows, and if he says he's not familiar, then we can move on.
Yeah. And okay, well, I thank you for your time this morning. Thank you, Mr. Chairman.
Any other questions, any other board members?
No, I think.
Go ahead, Mr. Salim. Is there
No,
anything?
I just wanted to say, thank you guys for your time. Thank you guys for bearing with me. Actually, it's the 9th day of Ramadan, so I'm fasting, so I'm not all the way there. So I just wanted to, because I haven't had obviously coffee or anything this morning, so I'm kind of a little bit, I feel like I'm dazed a little bit. So I don't know if I came off that way.
Not at
No,
all.
you're fine,
All
sir.
right.
I know that you're that's fine, sir. I just want to say, Mr. Salim, you've been linked to establishment that has had 3 violations. If the board was to move forward to approves this license, we want to make sure that we don't see this establishment in front of us for not complying with the law. So the purpose of this hearing is just to get clarification on your involvement with these establishments, and to get assurances from you that we're not going to be seeing you again, because you're going to ensure that you're not going to sell products that are not bought from a legal dispensary or manufacturer in DC, that every medical patient that comes into your establishment, they'll have a medical card to purchase, that you will also participate in the metric system. And so that is just some of the concerns that the board has, to make sure that we don't see you again, because if we were to see you for you're not complying with the law, there are measures that the board would have to take, because now that this is on, you're the 100% owner of this establishment, and so you are fully aware and fully in charge, and the board will hold you responsible for any illegal action that's taken by you or any of your employees.
Definitely. Mr. Anderson, I wanted to assure you, you know, that, you know, you guys, hopefully, you know, we're not to run into each other or see me, because, you know, that's it.
And if he
Yes,
has any
Mr.
questions regarding proper operations, he can always come to our office and we can advise him appropriately.
All right. Thank you very much, Mr. Salim, for your appearance this morning. Mr. Mixon, have a great day. The board will take this matter under advisement. We'll advise the agency of the next steps that should be taken towards the issuance of this license. All right?
Thank you, guys. Thank you, guys.
Thank you, Mr.
Have a
Chair.
great day. Thank you. All right, Mr. Oriana, the next case is Green Cloud Shop, license number 130775. Mr. Oriana, good morning again. Can you please elevate the parties for this next case?
Sure. Abdel Haq Hamsase, access elevated, and that appears to be our chairman.
Thank you.
My name is Abdelhak Hamsasi.
All right, can you come on camera, sir? And are you able to come on camera?
Yeah.
Good morning, sir. Can you please spell and state your name for the record, sir?
My name, good morning, everybody. Good morning, Chairperson Anderson and the members. My name is Abdelhak Hamsasi. I am the sole owner of the Green Cloud location at 6124 Georgia Northwest.
Spell your name, sir. We have a court reporter, please.
My name is ABDELHAK. Last name is HAMSASSE.
Pronounce it again for me one more time, so that you're just your last name.
Last name is Hamsasi.
Hamsasi. Okay.
Hamsasi.
Okay.
So HAMSASSE. And first name is ABDELHAK.
No, I was just asking to pronounce it because I'm going to refer to you by your last name, so I won't butcher it too much. Okay.
Thank you, Mr. Thank you.
Mr. Hamsasi. Okay.
Yes, sir.
All right. All right, so you have applied for a medical cannabis retail license with delivery endorsement. There was a summary closure issued for Green Cloud Shop on September 24. Specifically, this the establishment continued to operate as an unlicensed cannabis retailer and sell cannabis and cannabis products in violation of DC law after previously receiving a cease and desist.
Right.
And so, and addition of the unlicensed establishment offered for sale psychedelic products including psilocybin, which are Schedule I substances. Okay, and there was an offering compromise that was signed. So let me. Were you the owner? And let me explain the purposes here. It's a fact-finding hearing.
Yes,
You're
sir.
not under oath. The board cannot take any action against you. So in the sense that this is a fact-finding hearing, we're just asking questions, gathering information. The board can say, we can't order you to take any specific action because it's a fact-finding hearing. And again, you're not under oath. And so nothing that you said here can be used against you in a court of law because again, you're not under oath. So I'm just asking, you have applied for a license. The board is in the process of determining whether or not this license for Green Cloud Shop should be issued. And so we just want to make sure that if this license is issued to your establishment, that we'll never have there'll never be another summary action against your action, that you will comply to this establishment will comply with the law and the rules and regulations of selling cannabis, medical cannabis within the District of Columbia. So I guess what I'm trying to find out, so the previous action that was taken under Green Cloud Shop, were you the owner of that establishment, sir?
Yes, sir. I saw the owner.
So and maybe you can just provide some information that if you're a sole owner and you're aware of what the law is, why did you continue? I mean, why do we have this summary? So can you please explain your prior involvement in actions that led to the summary closure?
Yes, I previously operating my own business at the location 706 Kinder Street. I was operating under the I-71. After COVID, I start at April 2021, and after the enhancement of the new legislation of Washington D.C., I was forced to seize my shop by the ABCA in September 13, 2024. So after that, we lost the location, and we had to move to a new location in Georgia Avenue.
So I guess what I'm trying to find out, so you were a former I-71. How long, and I mean, and this is positive. Oh, you said, so how long did you operate as an
We
I-71?
operate for 2 years.
3 years?
Yeah, 2 years. And so from 2001 to 2002.
And so how large was, I'm sorry.
2001, 2004, September, because we got closed in September, 13 September of 2024.
And how large was your business? I mean, I'm just trying to find out your history to say what background you have in the industry.
Yeah, my background, because I have my brother-in-law who have a business of tobacco business in Washington, in Virginia. So and I used to assist him. So and after that, I had an opportunity to open a business, a regular grocery shop in Washington D.C. And I find out that everyone doing I-71, and I start doing the I-71 by buying stuff and sell it to the districts of Columbia. So when the new law came out from Washington D.C., they asked me to shut down the business and try to apply for the legal license from DC districts. So what happened? I got shut down, and I was interested for the business to follow with the business. So I apply legally through the cannabis, through the ABCA of Washington D.C. to get a legal legal cannabis license, medical cannabis license to operate.
All right. So the business was closed down in what? When was the business closed again?
Is it, I think September 13, 2024.
All right.
So,
All right. So is the ownership still involved in any illegal cannabis activity?
no,
Are there any mitigating precautions set in place to ensure that illegal activity will not occur again?
no.
No, I think I think the answer to that question
Yes.
should be yes. But no, I know what you meant. So that's
Yeah.
why I'm correcting you, because I know what you meant, but you answered it correctly. So let me ask you the question again. Okay. I said, are there any mitigating precautions set up in place to ensure illegal activity will not occur again?
Yes.
All right. Okay. I know what you meant, but
Yeah.
I knew you responded incorrectly. Um, how can you ensure us that this will not occur again?
Um, because we doing some training, like legal training, and we complying with the DC law. So since we got punished by losing our shop, so we're not gonna do it again. So yeah.
All right. So you said that, is it correct that you said that are you the 100% owner of this establishment?
Yes, sir.
Uh, just explain to me your business model.
My business model is just like a solo owner business. I don't have no franchise. It's gonna be only one shop. It's gonna be operating in 6124 Georgia Avenue Northwest. My wife is gonna be the team manager, and we've been taking some classes online with to get hands on in the matrix, and also we've been taking classes with the patientforcertification.org, and also we registered the matrix with the Marijuana Software LLC. So all the training will be conducted through them, through the patient for certification, and we're gonna make sure the resource and maintenance education training for our team.
Do you plan to hire any management team to help you run your business, sir?
Yes, sir.
Have you identified one as yet, or
Yes,
is that?
I have my wife. Her name is Hanan Al Mahfoudi. She's gonna be the manager, and I have a friend of mine who is gonna be helping us. So the location is ready to go because we listed the location last year in January 2024, and we've been paying rent for a year, and we never sold any items or any product in that location. So we're just waiting for the license to operate. So the business is ready to go. So we have the team, we have the certification, we have everything for the knowledge and training. Thank you.
Does the ownership understand that it can only distribute, store, and sell medical cannabis products provided by DC licensed cultivation centers and manufacturers?
Yes, sir. So we're gonna get all the product from DC.
Uh,
Yeah, from
Does
the city license legal cannabis.
does the business understand that? Does the business have any Schedule I substance in its possession, either on site or on another location?
Yes, sir.
Does the business have any non-medical cannabis products in its possession, either on site or another location?
No, sir.
Does the business understand that the presence or distribution of Schedule I or non-medical cannabis products may lead to the closure of the business or the revocation of the license?
Yes, sir.
Any questions by any other board members?
No, I just
No, no, I'm sorry. I was asking if there were any
sorry.
questions by any other board members.
No, I don't have no question. I just want to Thank
No,
you.
I was asking the other board members, so if they
Oh, the
had
board
any
member?
questions of you. No? Any final comments that you want to make, sir?
No, thank you. I just want to appreciate for your help and for all the advice you've given us. Thank you very much.
All right. Mr. Hamhassi, if this board issues this license, you've been involved with illegal operations prior, and I'm glad that since September of 24, when the business was shut down, that you did not continue to sell products, but just be mindful that if the board issues this license, we hold you to a high standard in the sense that you are providing medication to residents of the District of Columbia. You can only provide medication to folks in the District of Columbia who have a medical license, because as you know, only medicinal cannabis is legalized in the District of Columbia. So everyone who purchases must have a medical card to purchase. And so just need to make sure that everyone who you serve has a medical license, and that you only purchase legal products from a licensed distributor, or I'm sorry, a licensed cultivation center or a manufacturer in DC. Okay, sir?
Yes, sir. Thank you very much. I understand.
All right. All right. So the board will take this matter under advisement, and we will advise the agency of the next steps towards the issuance of your license. Thank you for being here today. Have a great
Okay,
day.
thank you very much. Take care, everybody. Thank you.
Bye-bye. All right. The next matter is a summary action matter. It's case number 25 ULC 00055, Good Smoke. Ms. Doriana, can you please elevate the parties in this case?
Sure thing. Betsy McMullen, access elevated, and Yama Shansab, access elevated. That is all true.
Thank you. Yama Shansab, all right.
Yes, good morning.
Good morning. Ms. McMullen, can you please identify yourself for the record, please?
Assistant Attorney General Betsy McMullen, BETSY, MCMULLEN, here on behalf of the district.
Good morning. Mr. Shansab, can you please spell and state your name for the record and your identification, sir?
Of course. Good morning, Chairman Anderson. My name is Yama Shantab. My first name is spelled Y-A, M as in Mary A. And my last name is spelled S-H-A-N as in Nancy, S as in Sam, A as in Apple, B as in boy, Shantab. And if you prefer, you can just call me Yama. I blame the last name on my parents, so, you know.
I'm gonna, without butchering your pronunciation, sir, I'm gonna try to pronounce your last name when I reference you. So I'm not gonna blame your parents that this is the name that you have, and it's incumbent upon myself to figure out how to pronounce it properly. Okay?
That's perfectly fine. Thank you. And Chairman, if I may, we have a witness by the name of Anthony Mora. He should probably be in the attendee list, and he would be called as a witness.
All right, so Mr. Arena, can you elevate that person if okay, fine. So Mr. Shansa,
Yes.
what is your relationship to this establishment? I'm
Your
sorry,
Honor,
what's your relationship? Why are you here? Who do you represent? Let me put it that way.
Thank you very much, Your Honor. By way of just a very brief opening, Chairperson Anderson and members of the board, I represent Charles Russell Properties, LLC. It is the owner of the premises at 1843 14th Street Northwest, second floor, It is not a cannabis licensee. It has never held a cannabis license. It is not cited or charged or alleged to have operated an unlicensed cannabis business. The summary closure at issue arose against a former tenant, this entity called Good Smoke Inc. And it arose under DC Code Section 7-1671.08G1 because that now former tenant, Good Smoke Inc., was charged with unlawful conduct. Now, that section authorizes emergency closure where the operation of a cannabis establishment presents an imminent danger to the health and safety of the public. And whatever the violations of the former tenant may have been committed, it has vacated the premises. There is no cannabis being sold. There is no ongoing operations at the location. The statute's authorization of emergency abatement has been fulfilled. It does not authorize indefinite exclusion of a non-charged property owner, which is what Charles Russell Properties LLC is, after the unlawful activity has ceased. So, Chairperson, the question before the board today is narrow: whether the summary closure authority continues once the alleged unlawful activity has ended and the unlicensed entity with which my client has no affiliation, Good Smoke Inc., and the former tenant has vacated. And we respectfully submit that it does not, and we ask that the premises merely be restored to the owner. And we'd like to present testimony of the manager of Charles Russell Properties LLC, Mr. Mora, the title owner of the real property.
All right. So, Ms. McMullen, I mean, there was a summary action. It's my understanding that the agency has possession of the key. So what is it that this board has been asked to do today?
Yes, Chairperson, members of the board. As Mr. Shansub stated, we are today on an underlying summary action. On August 8th, 2025, the supervisory investigator Peru, along with other ABCA investigators, conducted an undercover buy at Good Smoke, the establishment at the premises, in this case that is owned by Charles Russell Properties, Mr. Shansub's client. Illegal cannabis was bought at this buy. On August 13th, 2025, ABCA issued a summary closure against the establishment, closing the premises due to, as Mr. Shansub cited, DC Code Section 7-1671.08G1, stating that there was imminent danger to the safety of the public due to this unlicensed cannabis. On August 22nd, 2025, I was contacted by Miss Amber Dior Smith, that is the co-owner of Good Smoke, the establishment. We entered into OIC negotiations, and on October 22nd, 2025, a order was issued by the board approving the terms, the OIC terms entered into between Good Smoke, the establishment, and ABCA. Part of the terms of that OIC issued in the board order were that a $10,000 fine would be paid, which would allow the establishment to receive the keys back to the premises. I was contacted on January 14th, 2026, 4 months after this order by the board approving the OIC, that Miss Dior Smith and the establishment had vacated the premises and had no intention to pay the $10,000 fine. I was contacted by Mr. Anthony Mora, the agent of Charles Russell Properties for this premises. We then attempted to enter into OIC negotiations, and it was unsuccessful, which is now why we are at a hearing today before the board. And we would just ask that the board, should it decide to issue an order allowing the premises to receive the keys back, that it issue an order including standard terms normally entered into an OICs, such as that the premises will not lease to another unlicensed cannabis establishment, and other such terms, which I'm happy to get more into.
So, it appears that there is no dispute. I mean, there is no dispute that it doesn't appear. And I guess, what is it that you are asking the board to do, sir?
Chairman Anderson, we are asking the board simply to return the keys to the landowner, to the property owner. The property owner has been locked out of the property for some time. If I'm looking at it as an outside party who doesn't appear before the board very often or at all, the emergency has abated. The tenant was the bad actor. It burned the board with an offer in compromise it didn't uphold. And it burned my client because it didn't fulfill those terms. It hasn't paid the rent. We issued a notice to quit. That would be one of the pieces of the record that we would present to the board today. As part of the record, we submitted exhibits 1 through 3. And the notice to quit has been posted. And what we're asking is simply to return the keys.
Apologies. Board Member Meadows is having an issue right now. He should be back up in a couple.
Yeah, hold on. I didn't realize that we can't operate. We need 3 members to operate, so I apologize.
1 second.
As I said before, our 3rd member is having some technical difficulties, and so the board can only operate when a quorum is present, and a quorum is 3 members. So. Our IT person is working with our board member to fix his
No problem.
issues.
I totally understand, Chairman.
Okay. That is unfortunate. One of the unfortunate drawbacks of working virtually.
Well, as someone whose laptop that I'm using right now went down this morning for an hour, giving me nearly a heart attack, I understand the issue.
I believe Mr. Meadows will be able to join us momentarily. I was told that he's signing back. He's signing back in. His computer had to be updated.
Thank
But as I said before, sorry for the delay, but these are one of the unfortunate things when we have virtual hearings. But fortunate for us, we've been operating virtually for since COVID. And we have been fortunate that we have not had, this is actually the first time that we've ever had such a breakdown in all these years. And we've been doing all our hearings virtually since March of 2000. So this is 7 years we have been operating. I'm not 2000. Since COVID was 2020, is that correct? 2020 was COVID. You know how soon we forget? Yeah, COVID. So we have been operating for 7 years. Since March of 2020, we've been operating virtually. So this is actually the first time that we've had such a break, and unfortunate because only 3 members were available to participate in our hearings today. If we had another member, we could have continued, but in order for the board to operate, we need a quorum, and a quorum for the agency is 3. And so that's why. Mr. Meadows, thank you for, I was told you had some technical difficulties. Thank you for being able to rejoin us, sir. Okay, we're back on the record. All right.
Yes, I apologize to everyone. Out of my control. That's electronics for you. For some reason, my laptop, my government laptop, has decided to do a complete reboot of my system. I don't know. I got a update yesterday, and I hit the button to say delay for 5 days. But I guess it went ahead on its own. Miss McMullen, my apologies.
Well, you should have updated yesterday, Mr. Well, no, we were in a hearing yesterday, so you couldn't have updated yesterday. And we normally don't meet on Thursdays, so we meet on Wednesdays. So that's why, that's what happened, Mr. Meadows. Your computer is not used to working on Thursdays. It's like, okay, I work on Wednesdays because Wednesdays is an ABCA hearing day. So if you want me to work a different day, I'm going to go on strike. All right, I'm sorry, Mr. Shansup. You were given your presentation of, I believe, what is it that you're seeking?
We are seeking a return of the keys, and that's all we're seeking, just a return of the landowner's keys. To the extent that the board believes that there are future conditions attached to that, we don't believe that the DC code empowers the board to compel prospective conditions upon the landowner without having charged the landowner with any wrongdoing. And I think that's what Ms. McMullen had suggested, that the offer in compromise terms, as she presented them to me, are quite onerous. They waive all notices in the future, a $10,000 immediate penalty. That isn't the statutory framework in DC between the two statutes, and between the regime applicable to Good Smoke Inc. and my client, which wasn't charged or notified of any violation on its part. So all we're seeking, Chairperson Anderson and members of the board, is just a return of the keys. I think that both the board and my client, Charles Russell Properties, have been victimized by the former tenant. I would note that that former tenant wasn't the original tenant. It was a tenant by an assignment. And so they hadn't been there for as long as the prior tenant. And they weren't apparently operating for some time. They were paying rent for some time, but not operating. And I would just want to note, for the record, to the extent the board isn't inclined to grant the relief requested, we would like to admit the exhibits 1 through 3 that we've submitted through Mr. Berman's and Ms. McMullen's office, or we can proceed with the testimony, Chairperson.
Thank you. Ms. McMullen, do you have the board? It would be hard pressed for the board to issue findings of fact and conclusion of law, or to impose any conditions on the landlord unless there has to be a factual record to for us to base conclusion of law, findings of fact and conclusion of law. So if you wish to call a witness to establish this, then the board would consider it. If not, what I will do is ask the counsel to put his case on, to put his case on, and the board will make a decision based on his presentation.
Chairperson, the district, so long as Mr. Shansab is able to appropriately show that imminent harm has ceased by way of the illegal establishment vacating the premises, the district sees no problem with the keys being returned. The one thing the district would like to just note for the record is to push back against Charles Russell's Properties' assertion that there was no notice of these proceedings. As you're well aware of the proceedings, Chairperson and members of the board, the landlord is always notified of these proceedings and in fact has an obligation to know what's going on in the premises it leases out. I have proof of an email with Mr. Mora CC'd on it that he was aware of these proceedings dating back to August 22nd. So I would just like to push back against any assertion that there was no notice of these proceedings, because the Charles Russell Properties has had awareness of these proceedings since August of last year. That being said, if proof can be shown that the imminent danger has ceased, the district sees no issue with the keys being returned.
That's fine. Do you have you stated that the landlord was on notice. Is that document in the record?
I have submitted it as an exhibit to Mr. Berman. I'm happy to
Well, if it's
testify.
if
I'm
no,
happy to admit it on cross of Mr. Mora.
uh, all right, okay, fine. I would like if that if there's evidence to the contrary, then I need that to be a part of the record. All right, so Mr. Chanza, do you wish to call a witness, sir? And then you can bring in all the documents that you
Yes,
so you
yes,
can
Chairperson, yes.
yes.
And just
Who's
by
who's your witness?
clarification, and
Yes,
just
sir.
by
Go ahead.
clarification, the notice of summary action was sent to both
You
the
can
operator.
you can bring that in.
All
Okay,
right,
so
very good.
you can bring that in if this witness can testify, or you can bring that in presenting your case. As I stated before, the board needs some record to
Yes.
make whatever decision we're going to make. When I need to have some record, so therefore some parties, if it was to go to the Court of Appeal, at least there's some administrative record that we will have. So that's one of the reasons why I'd asked Ms. McMullen if she had a witness she wished to call, because if she's asking the board to impose conditions on returning the keys or on future actions, then we would have to have some record to base that on.
Yes.
And so if there's none, then if you can show through your witness to say that, okay, this is where we are today, then whatever decision the board makes, it's based on some factual findings. Okay?
Perfect. Thank you.
All right.
Thank you, Chairperson. All right, if I may, I'll call Anthony Mora. I think he's in attendance.
Yes, he's here. Mr. Moore, can you raise your right hand, please? You swear or affirm to tell the truth and nothing but the truth?
Yes.
You're a witness, sir.
All right, thank you. Mr. Mora, please spell your name for the record.
Anthony Mora, Anthony. Mora is M as in Mary, ORRA.
And what is your role with Charles Russell Properties LLC, sir?
I'm a manager of the company.
Does Charles Russell Properties LLC own the commercial premises at 1843 14th Street Northwest, second floor, Washington, D.C., 2009?
Yes.
Did Charles Russell Properties have any ownership interest in Good Smoke, Inc.?
No.
Did Charles Russell Properties LLC have any role in operating or managing Good Smoke's business?
No.
Did Charles Russell Properties LLC ever hold a cannabis license issued by the ABCA?
No.
After ABCA initiated enforcement proceedings against Good Smoke, how did you understand that Good Smoke Inc. was working directly with ABCA regarding compliance?
I was CC'd on an email between our tenant and Ms. McMullen.
And how did you become aware that Good Smoke later entered into an offer in compromise with ABCA in connection to those proceedings?
I was CC'd again on an email between them and Ms. McMullen.
All right, at this time, I think the board has been provided, and Ms. McMullen was provided in advance, Charles Russell Properties LLC's Exhibit 1. And Mr. Mora has a copy of that in front of him. And I can also
you can if you want we can allow I can have our IT person allow you to share your screen so you can show us that document, sir. Do you want to are you able to share your screen with us? Or that's that?
You might be exceeding my
All right, then that's fine. All right, that's fine. So you said that the document was disclosed. You have a copy. Miss McMullen, do you have a copy of the document that he's referencing?
I do, Chairperson.
Okay, you can go ahead then, sir. I'm not going to ask you to do anything further. Go ahead, sir.
Okay, thank you. Mr. Mora, you've seen this document that's been marked Exhibit 1. Do you recognize it, sir?
Yes.
And what is it?
It's an email from Ms. McMullen to our tenant.
All right, and were you copied on this communication, sir?
Yes.
And what is the date on this document?
August 28th, 2025.
And it is an it is an email exchange. Is that accurate?
Yes, it's a response.
There's an email, there are two emails, one from this lady, Miss Dior, and one response from Miss McMullen. Is that right?
Yes.
And what was your understanding about what Miss McMullen said in this email?
That Charles Russell Properties, as the landlord, would not be responsible for any fines or appearings at any hearings.
All right. And did you rely on that representation in Exhibit 1 by Miss McMullen?
Yes.
All right. I move to admit Exhibit 1 into the record.
Ms.
Just
McMullen?
an objection to the relevance here. I know that notice has now been brought up by myself as well, but whether or not the awareness of the proceedings do not relate to what we're here to discuss here, which is whether or not imminent harm has ceased, and as a result of that, whether or not these keys can be returned. I think this whole fight over notice and Charles Russell's Properties awareness of the what's going on inside their property does not have anything to do with whether or not imminent harm has ceased in this case.
Okay, if I may respond to that, if that's the position of the government, the relevance of the email is simply that there was no notice of any charge against Charles Russell Properties and that it wouldn't be responsible for any fines. We can go right into the issue of whether the harm has ceased next, but we think that the Exhibit 1 is relevant to the question of were they on notice that they were being charged?
I'm gonna overrule the objection and move the document in evidence. Miss McMullen, you can cross-examine him on his knowledge on the document, but I'm gonna allow the document to evidence. So go ahead, sir.
Thank you, sir. Did Good Smoke ultimately fulfill its obligations, Mr. Mora, to ABCA under its compliance efforts, as you understand them?
No.
Did Good Smoke continue to pay rent under the lease?
Initially, yes, and then they stopped paying.
Did the tenant fall into arrears?
Yes.
Let me ask you to look at what's been predisclosed and provided to Ms. McMullen as Charles Russell Properties Exhibit 2. And I believe, Mr. Mora, you have a copy of Exhibit 2 in front of you, sir. Is that right?
I do.
And after the tenant failed to fulfill its obligations and failed to pay its rent, did your LLC take action as the landlord?
Yes.
Let me ask you to look at Exhibit 2. Do you recognize it?
Yes.
Does it reflect a 72-hour notice to quit issued to Good Smoke Inc. for non-payment of rent?
Yes.
Did you sign it, sir? Is that your signature at the bottom?
Yes.
All right, I move Exhibit 2 into the record as the 72-hour notice to quit by Charles Russell Properties to Good Smoke Inc.
Any objection?
No objection.
Without objection.
Thank you. And Mr. Mora, the date on the notice to quit is January 6, 2026. Is that right?
Yes.
All right. Now, there's a second page to Exhibit 2, and it's an affidavit of service in blank. Do you see that?
Yes.
All right. Let me ask you to look at Exhibit 3 now. This is Exhibit Charles Russell Properties, LLC, Exhibit 3. And this was also pre-disclosed, Chairperson Anderson, to Ms. McMullen and Mr. Berman yesterday. And Mr. Mora, do you have a copy of Exhibit 3 in front of you?
Yes.
All right. Can you tell me what that is?
An affidavit of service from our process server.
All right. So you had this affidavit of service prepared by the process server?
My counsel did, yes.
All right. And was the notice to quit posted that we saw in Exhibit 2 according to this affidavit of service?
Posted and mailed.
Posted and mailed. I move Exhibit 3 into the record.
Any objection?
No objection.
Without objection.
All right. Mr. Mora, after you submitted a notice to quit and served the premises and the principal of Good Smoke Inc. with a notice to quit, did Good Smoke vacate the premises, sir?
Yes.
Is Good Smoke currently operating at 1843 14th Street, second floor, or anywhere on those premises?
No.
Are there any cannabis products currently present at the premises?
No.
Is any cannabis retail activity occurring there today, sir?
No.
In connection with Good Smoke Inc., what charge or violation was leveled against Charles Russell Properties LLC under the DC cannabis laws as you understood them?
None.
Is there any ongoing cannabis activity at all occurring at 1843 14th Street Northwest, whether it's on the second floor or any other part of the premises?
No.
Do you have prospective tenants, sir, currently that are looking to rent this space that's been padlocked?
Yes.
And do you believe yourself to be losing rents as we speak?
Yes.
I tender the witness.
Ms. McMullen, do you have any cross?
Yes, Chairperson. Good afternoon, Mr. Mora. If I may share my screen.
Mr. Oriana, please allow Ms. McMullen to share her screen.
Access granted.
Thank you, sir.
Thank you. I'd like to present to the board and to Mr. Mora what has been previously marked as Government Exhibit 1. Mr. Mora, can you see this screen?
Yes.
Could you please read this email? Have you seen this email before?
Yes.
Could you please read it to the board?
This looks like it's Amber at amberdiorllc.com to Good Smoke, which is goodsmokedc@gmail.com, Charles Russell Properties @gmail.com, and McMullen, Betsy, OAG. Thank you.
Sorry, go ahead. You can continue. Sorry.
Yeah, on 8/22/2025. Thank you for taking my call, Assistant Attorney General McMullen. Per our discussion, I have CC'd Anthony Smith, owner of Good Smoke, and Anthony Mora, representative of Charles Russell Properties, to this email. All parties are aware that you will be dealing with Amber Smith directly to get this case resolved. Please let us know the next steps once you speak with your client. Thank you in advance for your help and have a great weekend. Amber Dior.
Thank you, Mr. Mora. And is this email charlesrussellproperties@gmail.com? Is that your email?
Yes.
And do you remember receiving this email?
I do not recall specifically this one, but
And when was this email sent?
when was it sent?
Yeah.
August 22nd, 2025.
Chairperson Anderson, I would ask that what has been previously marked as Government Exhibit 1 be entered into evidence.
Any objection?
I simply object on relevance.
Chairperson, I would ask that if emails taken out of context from the premises aside may be entered into evidence, then this showing notice may be entered as well.
I'm going to allow the document evidence. So I'm going to overrule the objection. So I'm going to allow Exhibit 1 in the evidence.
Thank you, Chairperson. I will now stop sharing my screen. Mr. Mora, were you aware that there was illegal activity happening at the premises you leased to Good Smoke?
No.
And do you have any concerns that were you to lease to a new establishment, you might not know again that there is illegal activity happening at the premises?
No.
Objection beyond the scope of the direct examination.
I would say that if we are speaking on forward-looking provisions, then it would matter the awareness that the landlord has on the goings-on at his property to determine whether this may happen again.
I'm going to overrule the objection, so the witness can answer the question.
Can you repeat it one more time?
If you had no awareness of the illegal activity happening at your premises when Good Smoke shared the lease, do you have any concerns that this may happen again were you to rent to a new tenant?
Same objection and speculation.
Same question.
I'm going to overrule the objection. You can answer the question if you can.
Can you repeat one more time?
Since you were unaware of the goings-on, the illegal goings-on when Good Smoke held the lease at your property, do you have concerns that the same thing may happen again were you to lease to a new tenant, your unawareness of the illegal activities at your property.
I would be concerned, yes. But unable to police my commercial tenants at all times.
And you said that you had interest from new tenants. Have you researched these possible new tenants' backgrounds to confirm that they are not more illegal, they are not more establishments that would enter into illegal activity?
Objection. This is completely irrelevant and outside the scope of ABCA's functions, whether he has or what kind of tenants he may have lined up. The regulatory authority of the ABCA doesn't allow this kind of questioning because it doesn't allow Ms. McMullen to police a private landowner's prospective tenants.
I would argue that it's directly ABCA's concern whether or not more illegal cannabis establishments are being run.
Yes, but Chairman Anderson, the objection is that we don't regulate future unknown conduct. That isn't, it's a hallmark of our laws in the US still, more or less.
But we have proof that this landlord was unaware of bad actors before, and there we have concern that the imminent danger, in fact, has not fully ceased, but has just ceased for a temporary period of time. And the full cessation of imminent danger is what allows these keys to be returned.
There's absolutely no evidence that there is an imminent danger that remains. There's only evidence in the record that the prior tenant has vacated.
I'm gonna sustain the objection, and in previous cases I would have overruled the objection because there was a factual basis that the landlord was in. There were documents and evidence to say that the landlord was a part of this, was served, that the facts leading up to this case, and I've seen previous offers in compromise where as part of the offer in compromise, the landlord does agree that they're going to allow ABCA to monitor the tenants to make sure that they don't rent to another person who's selling illegal cannabis. But that's because the record supported all those facts are not in this record. So I'm going to sustain the objection. Let's move on. All right.
Thank you, Chairperson. Mr. Morrow, where is the office you maintain as part of your duties for Charles Russell Properties?
In Brooke, Virginia.
In Northern Virginia. Sorry. Okay, thank you. And how often do you check on the properties you lease to?
This is I'd rather, it's a long-winded, Charles Russell Property owns some residential real estate in Washington, D.C., Northwest, close by to this property. I would say I pass by this property weekly.
Weekly. And on these pass-bys, you had no concerns that there were illegal cannabis sales happening?
Objection. Same objection. This is plowing through the same ground, Mr. Chairperson.
Chairperson, I believe that we need to ensure that the landlord is aware of what's happening at its premises.
I'm going to overrule the objection, but I think I'm going to overrule the objection, but I think, as I stated before, one of the problems I have with this case, there's not a lot of facts on direct testimony, in a sense that the record, we don't have a large record on this case. So, but I'm going to overrule the objection. You can answer the question, and then yeah.
I can ask the question again, and just want to note for the record that the case report is part of the record here.
Not this. Well, it's part of ABCA's record, but it's not. It's not. I'll get some. I'll get clarifications later on from our general counsel. But so the case report is part of the record, but I'm not sure if it's a part of this particular case, so I can't respond to that currently.
It's our current understanding that it is, and I know that the case report has been sent to Mr. Shansub in his preparation for this hearing. But I can re-ask my question. Mr. Moore, when you would drive by this establishment weekly, and as per the case report, there were signs outside showing that they were selling cannabis. Did you have any concerns about illegal cannabis activity at this premises?
I did not see any such signs.
Your Honor, or sorry, Chairperson, may I refer to the case report? I can pull it up.
You asked him about the signs. He said that he wasn't aware, so I'm not quite sure. Bringing the case report, how is that going to help answer the question? He said he didn't see the signs, so.
Yeah, I'm just going to object. She's looking to, it's improper. It's an improper attempt to impeach the witness. And I would like to just point out that Ms. McMullen said that the issue of whether Mr. Mora or Charles Russell Properties had notice of the proceedings is irrelevant to the return of the keys and the disposition of this matter. I don't disagree with her on that point. That's the one point we seem to agree on. And this entire line of questions is irrelevant.
I think I know where the government is going. I mean, I don't think the government is opposing the keys being returned to the client, to your client. I think the government's position is that, yes, the keys can be provided to your client, but we need to ensure that your client does not rent to another illegal cannabis business, and your client has provide access to ABCA for us to know who the tenant is, to ensure that you're not renting to another illegal establishment. I think that's where the government is going, sir. That's their position. And so, as Ms. Mullen has started off, she wanted us to state that, okay, the keys can go back, but these are the conditions that we want you to comply with. But so that's where she's going.
Right.
That's why I'd asked her if she had witnesses to put some facts in the record. And so if the board is going to rule on conditions in returning the keys, so yes, you're going to get the keys back, but are there any future conditions that you should comply with? And that's where this case is. Okay.
Yes, but without the landowner having been named a respondent in this proceeding and having received notice of its status as a respondent, there's simply no statutory authorities to impose conditions. These conditions that Ms. McMullen has sought to impose by an offer in compromise are in the nature of equitable servitudes on the property. They are clouds on the title of the property. And that there is no DC legislation that permits that under these circumstances. None at all. None at all.
All right.
And it may be something that is extracted in the form of leverage to settle to get property back with other landowners through the offer and compromise mechanism. But there is no statutory grant to this board that permits that kind of imposition of conditions prospectively.
So I'm gonna sustain the objection. I guess my concern, Ms. McMullen, you're correct. Under 9715.10, yes, the case report is considered an exhibit, but I'm trying to figure out why is it that you want to. The question that you asked the witness, did he see the signs? He said he wasn't aware of it. So I'm not sure why. Is there something in the case report to say that yes, to prove that he saw the sign? Because that's my concern is.
Chairperson, I of course cannot speculate as to Mr. Mora's vision or lack thereof on any given day. The case report shows that it's my understanding that there was a sign out there daily, and I have picture proof of it through the case report. So that was my
and that's fine. I mean, that's fine. I mean, we'll take notice that there was a sign there. He stated that he never saw it. I mean, you can't dispute
Yep.
dispute that. So let's move on. All right.
Okay. Thank you, Chairperson. Mr. Mora, what practices do you have in place to inspect properties to ensure that tenants are in compliance with the lease terms?
I'm just going to object to the relevance of this. This is not a respondent before the board. This is a property owner whose property has been locked up and needs to be returned. There's just no basis for Ms. McMullen to ask these questions. It's just irrelevant.
Chairperson, presumably there are terms in the lease that state that illegal activity will not take place on the premises, and it here clearly was. So the government just wants to see if there's any compliance efforts on the landlord's part to ensure that the lease is followed.
I'm gonna overrule the objection.
Can you repeat one more time?
Yes, of course. What practices do you have in place to inspect properties to ensure that tenants are in compliance with the lease terms?
Our commercial leases state that our tenants will not break any DC laws or regulations, statutes. We expect them to uphold the lease agreement with us.
And do you have any practices in place to ensure that compliance with that?
Same objection.
And I'm gonna overrule the objection. You can answer the question if you can.
We visit the properties on an annual basis, fire inspections, things to uphold DC Department of Buildings regulations. If it makes the board feel any better, we own the building next door, 1845 14th Street. It's a commercial kitchen. We are around. Well, I did not see any signs, whether they were putting them out certain hours. I work in the daytime. I come and manage our residential properties. I pass by, we make sure trash is being picked up, properties are clean. I don't have control 24 hours a day over all the practices of all of my commercial tenants.
Chairperson, if I could share my screen really quick, I just want to ensure the board sees this picture in the case report.
All right, you can, Ms. Dorian, does she still have the ability to share a screen?
Thank you. I'll be done
Yes,
soon, I
she's done.
promise.
Yeah, thank you. Go ahead.
Thank you. Okay, I am sharing my screen. This is a picture from page 4 of the case report of this case 25 ULC 00055. Mr. Mora, you just stated you go in the daytime. I just wanted to share this picture in the broad daylight of not only a posted sign that seems to be pretty permanently posted, but this temporary sign. And it is your assertion you've never noticed either of these signs. Driving by weekly.
I had never seen that sign that says now open, the A-frame.
But you have seen this permanently posted one?
At one point, I
object to the reference to permanently posted, but
that's fair. I can reword. You
Okay.
have seen this one that seems to be stuck in the ground.
yes,
Just
it's no
to
longer.
reference this
Yes, it's
metal
no
tire one.
longer. It's no longer there.
Okay. Thank you. Okay, that's all the questions for me. Thank you, Mr. Mora.
All right, thank you. Before I just want to ask, I just want to get some clarification from council. This is from the Landlord's Council. 1 minute, please.
yes, sir.
No, just give me a minute, please. Well, no, I'm gonna ask. I have a question to ask you, but I will wait until the witness is done. I'll just let me see if I have any questions for the witness. No, I don't have any questions for the witness. Any questions for the witness by the board members? Mr. Chansub, any redirect?
I suppose I would, since Ms. McMullen asked Mr. Mora to read into the record part of an email, I would ask him to turn to Exhibit 1, which is in the record. And it's Ms. McMullen's email in response to the tenant's question about the landlord. And I would ask you to please read first the tenant's question to Ms. McMullen, if you would, Mr. Mora.
What exhibit is this?
Exhibit 1, sir.
Hold on a minute, please. Since you're not, let me see if I can find Exhibit 1. So, hold on, please. Let me make sure that I, since we're not sharing it, we're not sharing the screen. So let me see if I can find. It was sent to me.
I can try to upload it if you'd like.
Well, no, you don't need to. I found the exhibit. So I don't want us to have any more technical difficulties. So
I don't want to crash the system.
Right. So let's go ahead, sir. I have it. Yeah.
All right, Mr. Mora, could you please look at Miss Amber Dior's email? This is the tenant's email to Miss McMullen, and start please with "just want."
Just want to be clear that my landlord, Anthony Mora of Charles Russell Properties, is only CC'd on this email as a formality and will eventually have to confirm that he is okay with us reopening in his building after ABCA official approval, of course, but he nor his company will be charged a fine or called before the court for this matter. The $10,000 fine is solely the responsibility of Anthony Smith / Goodsmoke Inc. Correct? Question mark.
All right, and if you would please read Miss McMullen's response to Amber.
Hey, Amber, you are correct. The landlord of the property does not need to be involved in any further proceedings so long as he is okay with Goodsmoke continuing to lease the space. The landlord is not responsible for a fine or for appearing at any hearings. Thanks.
Did you rely on that email to understand that you were not the source of or a target of any kind of enforcement or violation of any sort?
Yes.
I rest the landlord's case subject to just closing.
Well, that's fine. The question I want to ask you though, sir, is that, and you can, as part of your closing, you can respond to that. The summary action notice that was sent August 13th. Do you know whether or not this notice of summary action, whether or not this was sent to Charles Russell Properties LLC landlord, the landlord? Do you know whether or not that notice, the notice of summary action for this case that was sent August 13th, do you know whether or not it was sent to your client?
I do not, but I would notice that I have a copy of it from Mr. Berman subsequently, and it is addressed to Goodsmoke Inc., trading as Goodsmoke respondent. And I believe, Chairman Anderson, that there have been cases in the past before the board where when you have maybe an offer in compromise, and I don't have a photographic memory of this, but I don't believe that when the respondent is solely identified as the operator and has absolutely no connection to the landowner, and the landowner has been told, you don't have to participate in any hearings, there's no charge against you, there's no fines. Has there ever been some kind of a condition imposed by the board unless it was agreed to? So I understand that some landowners may wish to agree to those kinds of conditions, but in this case, the conditions that were being sought by Ms. McMullen are simply too draconian. So the answer is
objection. These are confidential settlement negotiations, and I do not think any of them should be on the record or spoken about.
But you asked the chairman to impose those.
Right. So no, I think in Ms. McMullen, you had stated that you'd wanted some conditions to be imposed. And the only question I'm asking, because the argument is that you are not a notice. So I'm just asking you, sir, whether or not your client did receive the notice of summary action, because yes, it's stated that in the matter of Good Smoke Inc., Good Smoke respondent, but I'm asking whether or not a copy of this summary action was sent to the landlord.
I do not know.
Okay. All right. Okay. All right.
And just by way of closing, I know we've sort of
No,
plowed.
the government. No, the government goes first, and then you go.
Oh,
Unless if you're ready for your closing. So the government goes first,
No,
and then
Ms. McMullen, of course.
yeah.
Thank you,
Go ahead.
Chairperson and members of the board. All right. May I proceed?
Yes, go ahead, ma'am.
Thank you, Chairperson and members of the board. We are here today to hear from a landlord that outright ignored illegal operations on the premises they rent out. It is Charles Russell's property's assertion that there is absolutely no connection, that it has absolutely no connection to Good Smoke, the establishment here that was conducting illegal business. However, that is completely incorrect. They in fact leased their premises and space to Good Smoke and were the landlord of Good Smoke. That is a clear legal connection. You've heard here today Mr. Mora admit that not only did he visit the establishment weekly, but that he also owns the building directly next to Good Smoke, to where Good Smoke Inc. was, which is 1843 14th Street. Therefore, Mr. Mora frequently saw, or at least passed by, Good Smoke Inc., where he has admitted to seeing a sign that reads medical dispensary with the address, and it says follow us on IG at Good Smoke DC. He saw that sign, he passed by the premises, and he did not once question whether illegal business was taking place, not to mention the fact that the lease, as he admitted, explicitly states that illegal business cannot take place on the premises per the lease terms. He has admitted that he does not have plans to strengthen any awareness of whether or not future tenants are also conducting illegal business, despite opposing counsel's assertion that there is no code to ensure forward-looking provisions. It is not clear, it has not been shown clearly per DC code that the imminent danger here that allowed the business to be closed has ceased. Mr. Mora passed by the establishment. He saw the signs. He said he was there weekly. He said he was there in the daylight when these signs were clearly posted per the picture and case report on page 4. And he did not have any concerns about the illegal business that may be happening. Charles Russell's property was served with this summary closure on August 13th, 2025, when it was enacted, and has shown that they've been aware of these proceedings. Emails between myself as counsel and Good Smoke, when the proceedings were just between, we're working out OIC settlements between Good Smoke and myself as counsel, are not relevant to this proceeding and have no bearing on this proceeding. What matters here is that Mr. Mora and Charles Russell's properties had noticed that there was illegal business happening. They did not make any effort to contact me before this, and in fact said that they would agree per the OIC to Good Smoke continuing to operate in their building, despite the fact that they had previously participated in illegal business. Further, you've seen that he has no plans to prevent any further business happening. The basis for allowing these forward-looking provisions are that we have not received proof that the imminent danger per DC code has ceased here, and we have not been shown any activities that Charles Russell's properties will take moving forward to ensure that illegal activity does not happen again. He drove by this place every weekly and did not have any fears about this establishment breaking the lease through its illegal activity. Therefore, the district is not convinced that this could not happen again, and therefore the imminent danger has only temporarily abated, not completely ceased. For that reason, we would ask that the board include in its order that the property owner be on notice that is this to happen again, they may be issued a fine per DC Code Section 7-1675.01B. And further, that this property owner waives the notice requirement set forth in DC Code Section 7-1675.01A, as they've clearly been on notice that are they to participate in illegal activity again, there will be legal consequences. Further, the district would ask that property owner agrees that it will not lease to any other illegal cannabis establishments moving forward. And that is what the district would ask. Thank you, Chairperson and members of the board.
All right, thank you. Yes, sir.
Chairperson and members of the board, the proceedings here arise under DC Code Section 7-1671.08G1. That provision authorizes summary closure where an establishment presents an imminent danger arising from unlawful cannabis activity. That authority is emergency and remedial in nature. It is tied to unlawful ongoing operations. Charles Russell Properties is not a licensee, it is not an applicant, and it is not alleged to be operating an unlicensed cannabis business. The tenant, the proof in the record has vacated. There is no cannabis activity occurring. The emergency condition that the statute addresses no longer exists. Now, the board acted to address what it believed to be unlawful activity, and that activity has ceased. The emergency has abated. Even Ms. McMullen, though she qualified it by saying temporary, says it has abated. The tenant was the bad actor. It burned the board. It burned my client. My client would only have allowed it to come back if it fulfilled the terms of the offer in compromise. But my client was victimized just like the board by that tenant. That tenant misled my client into believing it would comply with the board's OIC, but failed to do so and then failed to pay rent. There is no statutory basis to continue excluding a non-charged property owner from its own premises. We submitted a hearing memorandum yesterday that Mr. Berman acknowledged having received and supported the property owner's position legally, as well as a proposed order for the board's consideration. And we respectfully request that the summary closure be lifted as to 1843 14th Street, second floor, and that possession be restored to Charles Russell Properties, LLC. The issue that Ms. McMullen injected just a moment ago, that the order waive future notice to my client is extrajudicial, it's illegal. It's improper. There's no statutory basis for it. This board cannot waive statutorily required notices in the future to my client. So we ask simply that this case, maybe it's a unique way that it came to the board. Maybe there's some representations that Ms. McMullen prefers not to have made. I don't know. We're not blaming her or the board, but my client is innocent. Its property has been locked up for some time, and the conditions that Ms. McMullen has sought to impose are extrajudicial. They are not supported by the DC Code. We ask that the property merely be released, and we thank you for your time.
Thank you. Thank you for your presentation. And the record is now closed. All right. Okay. All right. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 25 ULC 00055, Good Smoke, pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act, and deliberate upon case number 25 ULC 00055, Good Smoke, for the reasons cited in DC Official Code Section 2-575B13 of the Open Meetings Act. Is there a second?
Mr. Chairman, Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll now have a roll call vote. Mr. Meadows.
Mr. Meadows votes agrees.
Mr. Jones.
I agree.
Mr. Anderson agree. As the motion has passed, I hereby give notice that ABC Board will recess its proceedings to hold a closed meeting pursuant to Section 2-575 of the Open Meetings Act. Thank you very much. The board will take this matter under advisement, and we will issue an order accordingly. Thank you very much. Have a great day.
Thank you very much.
Thank you.
Okay, all right. Yes. All right, as chairperson, I'm gonna, since we are, let me, hold on. Oh, I'm not done with the record. Okay, so that was our morning calendar. So let me now review the afternoon calendar. There's the afternoon calendar is case number 25 PRO 00104, signature lounge license number 117485. This hearing is canceled due to the submission of a settlement agreement for the board's review and approval. And so that's the end of our board's calendar for the day. There's no other business. Let me close the record. As chairperson of the Alcoholic Beverages and Cannabis Board for the District of Columbia, in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on March 5th for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for March 5th, as published in the DC Register on February 27th. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones has seconded the motion. I will now have a roll call vote on the motion that's been properly seconded. Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Anderson, I agree. As the motion has passed, I hereby give notice that ABC Board will hold this closed meeting pursuant to the Open Meetings Act. Notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar on APCA's website, and published in DC Register in as timely a manner as practical. We are now adjourned for the day. Thank you, board members, for your active participation today, and thank the members of the public who participated in our hearings today. I now ask all board members to return to executive session for further action. Good afternoon. Thank you.